Thank you very much, Madam Chairman. Rafi, thanks for being here today. I enjoyed your testimony, which you centered around this notion of disclosure, and you mentioned that that all that's being required here is disclosure. That was an exact quote. And the fact is, it's not just disclosure, though, is it? In order to follow through this process, there'd have to be a court battle, and there'd have to be a decision made by that court. Through you, Madam Chairman.
Yeah, no, you're correct. And I'm sorry if I didn't say that clearly. The disclosure. The disclosure is about disclosure as to why the tenant is essentially why an eviction is being brought because the tenant has failed to move. What is the reason that that tenant wasn't allowed to stay? And that is the point, really, at which disclosure becomes the issue. So you're right. It's not. It's where disclosure fits into the structure of the whole eviction process. But yes, this is a bill about evictions, and that's where the disclosure comes in.
Go right ahead.
Thank you very much, Madam Chairman. I'm just trying to follow the proper protocol of speaking through the chair. That's all. That's why I'm doing that.
I know.
Okay.
I don't need explanation.
Well, I understand. Well, you're.
Sorry, who's
it's me. I'm about to ask a question.
Okay.
Through you, Mr. Chairman, I appreciate that, except I wish we didn't have that interruption, because I really wanted to come right back to what you just said, which is this is a bill about evictions. But this is not a bill about evictions at all. In fact, I year after year, I complain about the title. To non-renew a lease is not an eviction. It becomes an eviction if this particular policy becomes law, but currently that's not an eviction. That's correct, right? Through you, Mr. Chairman.
The bill is about evictions. The bill is about determining, under the existing just cause eviction law, what are the grounds on which a tenant can be evicted. And it adds to the category of tenants who are protected by the existing law. The existing law is a law about whether or not an eviction can be, there's a ground on which an eviction can be brought. So, the law is about evictions. The law is not a law about leases.
Senator Sampson. Thank you very much, Mr. Chairman. This is going to take a lot longer than it needs to. I'm afraid. I asked just a very basic question, which is that under current law, non-renewing a lease is not an eviction. Is that correct?
That's correct.
Thank you. That's what I really wanted to get to, Mr. Chairman. Thank you. So this bill would create an eviction process, in essence. I understand that it already exists for certain members of the population, but it would create a whole new requirement for evictions that doesn't currently exist. That is correct too, right?
It eliminates a ground for eviction for this category of tenants. Yes.
Senator Sampson.
In a lapse of time or no longer has a right of privilege. From a legal perspective, those grounds would not be usable for an eviction.
Senator Sampson.
Thank you very much, Mr. Chairman. I just want to get us on the same page about what is actually happening here. That's also that we can talk about the policy, but we have to agree about what is actually happening, which is that there is a policy proposal before us, and you're testifying in favor of it, and I'm trying to understand it properly. But what I'm gathering from this language is that what's happening is, in a current circumstance where a landlord is simply not renewing a lease to a tenant that they, under current law, that would change if this becomes law. If a tenant decided they did not want to leave, now there would be required an eviction process where none currently exists. Is that correct? Through you.
If the tenant stayed and the landlord continued to not want the tenant to be there, but didn't want to do a lease, it would roll over to a month-to-month lease. But maybe it's because I don't understand where you're going with this that I'm having a hard time trying to answer the question in a way that you want me to answer. One would think it would impact a landlord decision on whether or not to keep a tenant, knowing that if the tenant doesn't move, the tenant could not be evicted unless the landlord is prepared to offer a reason. So I'm not saying it might not impact landlord behavior, but the bill itself deals with the grounds for eviction. I'm not sure I understand what your point is as to that difference. But I don't know how else to answer your question. I'm sorry. I just don't, because I don't. That seems to me that's the difference. But in terms of the bill, the question is, can the landlord, in a sense, enforce a decision that he doesn't want the tenant to be there by bringing eviction to put the tenant out? That's what the issue is with the bill.
Senator Sampson.
Thank you very much, Mr. Chairman. I appreciate our dialogue, although I have to say that I'm surprised that you're reluctant to just acknowledge the basic premise that I've offered, which is that now an eviction would be required where none is currently required. That's what happens under this law.
If the tenant doesn't move, yes.
Yes, very good.
I agree. Yeah, that's right.
And we've already established that it's not just disclosure. They don't just have to provide the reason. They have to not only provide the reason, it has to be a reason that is approved in the language of the bill. And there are many reasons that are perfectly legitimate that are not contained in the bill. And it also they also have to win their day in court. Am I correct about all those things? Is that correct, through you, Mr. Chairman?
Yeah, it has to be a reason that's listed in the statute. That is correct. And if it ended up going to court, it would have to be decided ultimately by a judge as to whether that reason had been established. Yes, I think that's correct.
Senator Sampson.
Thank you. I appreciate that. Now we're on the same page.
Okay, good.
Very good. So we've established that this bill now creates a new process where what used to be fine, and understanding that when you rented a property, you rented it for a period of time that was mutually agreed upon. The parties sign a contract that has a starting date and an ending date. Now, under this law, that ending date is now irrelevant from the tenant's perspective if they choose.
It is not irrelevant, but it's from the tenant's perspective. The tenant presumably would know, yes, if they don't do anything that's wrong, and wrong is defined in terms of what's the list of reasons under the statute, then they're not going to be able, that they are going to be able to stay. Yes.
Yes. All right. I appreciate that. Thank you, Mr. Chairman. That's very, very important, and I think it's very clear what we're talking about. It's even a little more onerous than you just described it too, because it's not just if they didn't do anything wrong. It's if the landlord is not willing to go through an expensive and protracted eviction process and take their chances in court, then that tenant will be able to stay. So effectively, this bill nullifies the expiration date of a lease, which is something that is the basic element of a contract, is it not? Through you, Mr. Chairman? You are an attorney, right? You do contract law. Through you, Mr. Chairman?
The way that you framed it is that applies in all cases. If the tenant doesn't pay the rent, that they can be evicted. But that doesn't mean that somehow that you don't have an eviction. And if you're saying, oh, well, you'd have to go through some kind of a process, of course you have to go through some kind of a process. So I was agreeing I agree with you that yes, the tenant is allowed to stay in the absence of doing something wrong. If the landlord claims he's doing something wrong, then it's the same process we have for anything else that the tenant would do wrong. The question is, what are the reasons? The statute controls what the reasons are.
Senator Sampson.
Through you, Mr. Chairman. Thank you. Except that I'm afraid that you're conflating a normal set of circumstances where an eviction might take place and the expiration of a term of a lease. These are not the same thing. They never have been. It's always been understood that if there is a difference of opinion on what's happening and during a tenancy where both parties are obligated for the term of time that is stipulated, presumably a year or whatever, then yes, the landlord would have to go through an eviction process if the tenant refused to leave. But under current law and under every sense of contract law since the beginning of time, The idea that you've rented the property for a year with an expiration date that you've both agreed to, this bill nullifies that in favor of the tenant's desire to stay there in absence of not only the disclosure of the reason by the landlord, but also by a lengthy, protracted, expensive eviction process where he has to prove that he's actually got a reason that is stipulated in the bill. Am I right about that? Through you, Mr. Chairman.
Mr. Podolsky?
What the bill does is it extends the existing law as it applies to elderly and disabled tenants in large buildings to a larger number of tenants, the other tenants who are in those buildings. That's what it does. So to the extent you're saying it does something that is unheard of, never heard of before, requires some kind of process, then no, I don't agree with that. To the extent that you're saying in the absence of regulation, if we didn't regulate in Connecticut the issue of expiration of lease, then probably that's a description that relates to a time in which we did not regulate this process. So I just think the thing I'm most disagreeing with is your reference to the complicated extensive eviction process. But the notion that this is something new and different and never heard of before, that's just not correct. It's well established. Practically half a century at this point.
Senator Sampson?
Mr. Chairman, through you, I appreciate your dialogue, Mr. Podolsky, but are evictions free? Do they happen immediately?
No, they do not.
Senator Sampson?
Through you, Mr. Chairman, I'm afraid to ask you this question, but how long and how expensive is an eviction for a landlord?
Mr. Podolsky?
I think the data the judicial branch has, and you could probably check this, is that the time in the court process, that's from return day to judgment, is a little bit over a month right now. So that's sort of the going time of an eviction. Some are longer, some are shorter. You would know the cost better than I would as to what the cost to the landlord is.
Senator Sampson?
Through you, Mr. Chairman, when is this month? When does it begin and when does it end? Is it begin on the day that the landlord says that they don't want to renew the lease?
No.
Through you?
No. It goes from return date to entry of judgment.
Right, and when does that?
That's my understanding of what the judicial branch data is about. Judicial would not have data. I don't think anybody has data on using other time measures.
Senator Sampson?
Yeah, through you, Mr. Chairman, and what do you believe that timeline is, assuming we're starting at the day that the lease is supposed to expire, and the landlord has an expectation the tenant is leaving on that day? What do you think the soonest that an eviction could actually take place, even if the landlord was in complete justification for wanting to not renew that tenant?
Soonest would probably be about a month.
I don't think that's accurate, sir. And I'm confident that there's going to be people that come before our committee today, and I'm going to ask people that are in the know on this to please bring that information when you speak to us.
Make sure you ask them the question you asked me, which is you said the soonest.
Okay. I will also ask what is typical.
Mr. Podolsky?
Oh, you're asking me? Mike, I think probably in an eviction, measuring from the date that the lease ended, probably 6 to 8 weeks, I would guess.
Senator Sampson?
Thank you very much, Mr. Chairman. I think we're going to find out from people that experience this that it takes considerably longer. And I think we're also going to find out that it costs maybe as much as the entire year's worth of rent to go through the process. I think that these kind of things are being minimized in an effort to move this bill forward. We talked about why the housing provider should be required to have a reason. And I think, speaking for me and a lot of other people, I think the reason is that we agreed on an expiration date. And both parties agreed, both the landlord and the tenant signed a document understanding that was the expiration. Can I just ask why, through you, Mr. Chairman, why you feel that's not good enough?
Mr. Podolsky?
Well, I've tried to describe to you in my introductory statement as to the sorts of consequences that come from the ability to use a lapse of time as the basis for eviction. I mean, we see it all the time. I mean, for me, I think the most common circumstances is the fear of tenants to complain about anything. The consequence is people. If you can ask almost any tenant, and you will find out that they are very nervous about making complaints because their fears there'll be consequences, and the consequence would be they won't get renewed. But then there are things that are actually sort of explicitly illegal. It's one of the ways you cover all sorts of discrimination. Those are the kind of things that happen. It has become a way to clear buildings of people. I mean, even one of the things we know is that it puts knowing that you can be put out puts tremendous pressure on people to move. It's sort of like a kind of self-eviction. You don't have to bring court cases. But one of the purposes of the bill is not to generate evictions, but to allow people to stay. One would hope that if the bill passes, it will discourage landlords from bringing evictions against people that they really don't want, that they don't care that much if they stay. And I think you're going to see. I mean, you talk about what does an eviction cost, but what does not bringing an eviction save? And you should ask that question as well.
Senator Sampson.
Thank you very much, Mr. Chairman. My question, by the way, was why isn't the time has expired good enough? That's what I had asked.
Okay, well, the reason is not...
Let me finish my question, and we'll speak through the chair if we can.
I'm sorry.
Rafe, I got tremendous respect for you. And again, forgive me if my questions, I'm not trying to be hostile. They're challenging, for sure. But I find this bill equally challenging. So I feel like it's very important for me to be able to get this stuff on the record. And you are one of the strongest advocates for this policy. You put testimony in on almost every bill on the agenda, but this is the one that you wanted to speak on. So I know you've been here year after year pushing for this. And I think it's important for people to hear it straight from one of the main advocates of this policy's mouth, why this is necessary. And I'm still not convinced that you've made a strong argument to me that this is necessary or valuable. You've thrown around a lot of terms like discrimination and complaints and so forth. In my view, the non-renewal of a lease, which is what current law would be, there's no... How can you have discrimination when you have a situation where the tenant was already accepted and presumably stayed in the apartment for the full year, and now the landlord simply wants to reclaim their own property that they paid for from that tenant? How does discrimination fit into that category? Through you, Mr. Chairman.
Mr. Podolsky.
Discrimination can come into play that you can have circumstances where people did not know. Discrimination can play on ethnic background. It can come into play on discovering someone is gay that you didn't know at the time they were that you rented to them. It can come into there's just all sorts of ways in which the discrimination comes in. Retaliation is actually more likely than discrimination because I would say to you it is much more common that just cause makes a difference where in regard to people who have made complaints to landlords.
Senator Sampson.
Thank you very much, Mr. Chairman. I don't agree. I think what you're adding to the equation is subjective. Hearsay, you might say, in a courtroom. I don't think there's any evidence or documentation or data to back that up. I would love to see it if you have it. Now, I'm not saying nothing like that has ever happened, but at the same time, how does that factor into the fact that shouldn't it still be up to the landlord whether or not they continue a contract that was mutually agreed beyond the terms that were originally agreed to? Like, for example, let me finish my question, please. Through you, Mr. Chairman. So shouldn't the dates on the contract matter as much as everything else? Like, if we're just going to negate the fact that the contract has an expiration date, why aren't we just negating everything else in the contract? Why aren't we suggesting that the tenant can choose how much they want to pay for rent instead? Or why aren't we suggesting the condition of the property or any of the other terms in the lease are not important any longer? This bill creates a situation where now one of the parties has to go to court to defend what they've already established as terms of a contract. And it goes so far as to limit their ability to do so to only the reasons listed. And again, I'm going to ask this question a final time. If you give me an answer, I would really appreciate it. But if not, I'll just move on to my next thing. But why, for the third time, I think, isn't the time expiring that was mutually agreed to on the contract signed by both parties with their eyes open, why isn't that good enough to satisfy the end of that relationship? Why would a courtroom and an eviction process be required? Through you. And I'll follow up to that is, what if the landlord said, no, you can't leave. I want you to stay. How come that's not addressed in this bill? Through you.
Mr. Podolsky.
You have to take a step back to look at what our policy is about about where people live and how easy or how difficult it should be to force them to move. And there's an underlying policy as to what is or is not okay. We regulate leases very heavily. There are all sorts of things that you can put into leases that we don't allow you to put into leases, and they cannot be enforced. We look at the situation. One of those aspects is we have looked at to what extent should it be possible to force people to move at the end of a lease. And that is where you have the existing just cause eviction statute. The question you're asking is, why should we expand it? I mean, you're actually asking, why should we have it in the first place? I mean, that's really the core of your question, is why do we allow anybody, why a senior, why do we allow anyone in certain buildings to have a right to stay? If the question is, should we extend it to anybody besides the people to whom we already have extended it, it's because of the adverse impact that it has on forcing tenants out of buildings and the collateral impact it has on our communities, on the ability of tenants to seek other forms of relief, on the ability of the tenant to explain that they are not in fact causing a problem, on the ability of a tenant to file a complaint with the Fair Rent Commission about a rent increase. All of these things impact why we would do this. So you're not starting on an open slate, on a fresh slate. And I understand you don't see that as an answer. But I think that the best, and there can be other witnesses who can answer this question better than I can, because part of the answer is, what are the social consequences of not having this right? What does that do, and why have we provided this protection for seniors, but we have not provided it for people who are 55 years old or who are 40 years old? That's a legitimate question, and you're entitled to an answer on that. But that's the question you're really asking, unless you're going back to the beginning and saying we should never have had a just cause eviction statute 50 years ago.
Senator Sampson.
Thank you, Mr. Chairman. The question I was asking was the same question I asked 3 times, which is, why isn't the expiration date that's been understood since the beginning of time as part of a contract good enough? You mentioned just now there are all sorts of things we restrict being in leases and contracts, and I agree with you. And I don't think that's really prudent in most cases. I think most contracts should be between the parties more than the government interfering with their transaction that they engage in freely as both mutual participants, including a lease for a rental property. But under your all sorts, the inception and expiration date of the lease is not one of those things. Okay, that's not something that is traditionally the government gets involved with determining. I just want to talk about a couple of other things. You mentioned, let's revisit the nuisance conversation that you had with Representative Weir. If you have a tenant that is a nuisance in a building, say you have a 6-unit apartment building, and you have one tenant that is constantly causing grief for the other 5 tenants that live in the building. And maybe it's because they park their car in the wrong parking space, they block the parking lot, or they leave garbage out on their patio, or they bring bugs into the building, something like that. In this particular scenario, walk me through how the landlord gets that tenant to leave, because they're fearful that the other 5 tenants that are minding their business and treating the place with respect and behaving with their neighbors in a way that is prudent and has good social consequences, to use your term. What's a landlord to do if they're trying to preserve the quality of life for the other 5 tenants in this building if they have that one problem tenant? How does that work under this just cause eviction bill? Through you.
Mr. Podolsky.
I think in most cases you're going to find the landlord is going to tell the tenant that they do not want the tenant to stay, and the tenant will end up leaving. That's what's going to happen most of the time. If this becomes an issue in which the tenant refuses to move, our experience is, number one, that other tenants are more than willing to testify if necessary. But more likely, especially in larger buildings, because remember that we're only talking about larger buildings, there's often a management structure in which the people who manage the building for the landlord will themselves have direct information about what is going on. They will know what complaints have been made, they're going to know what the situation is, and they're going to be able, if necessary, to go to court. If you look to see what has happened in other cases where people have brought nuisance cases, they win. Nuisance cases are won all the time by landlords. But in most cases, you're never going to get that far. Again, I don't know if I'm answering your question, but that's, I think, the best I can do for an answer at this time.
Senator Sampson.
Through you, Mr. Chairman. Thank you, and I appreciate the answer, although I don't agree with it, and I don't think it's accurate. But I did want to get you on the record speaking about this exact situation. And I'm going to ask people that are more knowledgeable, that have brought these exact claims to court, and they're going to explain the difficulties with trying to remove a tenant under the notion of being a nuisance. Because ultimately, there's a legal definition for what that means. And that creates a burden. And that's a burden that's very, very difficult to prove as a housing provider without the cooperation of the other tenants, who are very unlikely to cooperate. It's part of the testimony I hear over and over about this particular proposal is about retaliation. Well, I mean, again, this is another situation where I think retaliation would absolutely exist against a tenant that was willing to testify against another tenant or make a statement to say that that person was causing problems in the building and so forth. So I think a landlord have a very tough time to be able to document a nuisance in a way that satisfies the requirement in law. And we've had this testimony before. This is not the first time we've had this bill. We've had lawyers that handle these exact cases come before us and express the fact that it's almost an impossibility to be able to prove it to the satisfaction of a court. And here we are having this conversation about trying to get rid of someone who's clearly a nuisance, but the only thing that is changed is that the landlord used to have a mechanism to reclaim their property, and this takes that mechanism away. I want to shift gears really quick. My concern with this bill, and I got to tell you how frustrating it is to debate this topic or to have the conversation about it, because the folks that are watching that are tenants are furious with me. They think that I'm somehow sticking up for landlords and I'm trying to prevent them from getting a benefit that they deserve and everything else. The fact is that this bill is going to harm tenants. I'm letting it sink. It's going to harm tenants. You already acknowledged, Rafi, during our conversation that the notion of tenant screening is an issue, right? Do you think that if you create a situation where a landlord now is faced with the real probability that a tenant that they put in their building might become a permanent tenant that they do not have the right to remove after the end of their term? Question. It's a simple question. Are they going to be more or less restrictive, skeptical, or creating higher thresholds or requirements on the tenant before they approve them as a tenant? Through you, Mr. Chairman.
Mr. Podolsky.
The reason for the 1-year probation was to try to address that particular issue. And the bill accommodates that by including that provision.
Senator Sampson.
Your actual question was, will they be more cautious or not more cautious? Maybe. I don't know. It's hard to answer that question. But that is the reason that the bill includes a probationary period.
Senator Sampson.
Thank you, Mr. Chairman. It's not hard to answer the question. Frankly, it's obvious to anyone listening. They're clearly going to be more skeptical. They're going to set higher standards. They're going to set higher requirements. In fact, almost all of the policies that are being advanced, we had a conversation with the commissioner about restricting security deposits. The more of a burden you put on the housing provider, the more they want to ensure that the tenants that they do approve are tenants that are going to maintain the property, pay their rent on time, etc. So the guy that used to say, well, I'm going to take a chance on you, even though you only have a 600 credit score, he's not going to do that anymore. That's what's going to happen as a result of this bill. I just want to address the 1-year provision too, and I'll acknowledge that it is an improvement, because very often you're going to find out, what kind of tenant you have within the first year. But that's not always the case. I can tell a story as a small landlord. And that is that I had somebody that, and I'm not going to mention anybody's name here, but I had a tenant that was a phenomenal tenant for, I think, 5 or 6 years. In fact, the first couple of years when I would stop by every so often, maybe every 6 months or so, I'd walk in the place and I'd be like, wow, the place is amazing. It's remarkable. In fact, they were taking better care of the place than I ever would. Planting flowers outside, everything else. I mean, a very, very nice situation, and I was delighted to have them. And I never raised their rent because I didn't want these folks to leave, because I thought they were fabulous, and we had a good relationship. But this was a young couple. But several years later down the road, I got a phone call from the neighbor one night asking me in the middle of winter whether or not I was going to plow the driveway. And I explained that, well, under my lease arrangement with this tenant, the tenant's responsible. And they're like, well, they haven't been there and they haven't plowed the driveway. And I was surprised to hear this. So I went down to the property and I discovered that there was like 2 feet of snow. The last several snowstorms had not been cleared and the house had been abandoned. And I went inside and it was utterly and completely trashed. Drug paraphernalia all over the place, garbage, dirty diapers, everything else. Probably wiped out the last several years of rent and having to repair the property. The thing is that even after the snow melted, I found garbage in the front lawn. Mattresses, rusty old bicycles, thousands of beer bottles. The thing is that what I found out later is that in this young couple, one of them got addicted to drugs. And they took a very hard turn in their life. And while they paid their rent, I never missed a rent payment from them, which is why I never really checked up on them very well when everything had been so good for so long. But this just goes to show that, yes, 1 year is a good indicator of how a tenant might be, but you never know what's going to happen. Somebody could get addicted to drugs or lose their job or go through some other tragedy in their life that makes their situation different. So I wanted to throw that out there in respect to the fact that 1 year is not a solution by itself. It's helpful. My concern, again, I will say this one more time through you, Mr. Chairman, is the social consequences, as you mentioned. And I absolutely believe, and I mean this sincerely, this is the truth I'm telling you folks, that if you go ahead and pass this bill and it becomes law, I can promise you there will be less landlords in the state, and the ones that do exist are going to take fewer chances. They are going to take no more, well, I had a divorce and it screwed up my credit, or not, I lost my job for a while, or I had medical bills, or what. They're not going to do it anymore. And you know why? Because right now there is a limited number of available property anyway. This bill will have the effect of limiting the options for people that are the ones that are really in need of protecting. That's my concern. I mean it sincerely. If you don't want to believe it, fine. But I'm telling you, that's exactly what will happen. And I'm talking to people that are housing providers right now who are suggesting that they want to find ways out of the state and out of this industry because they are looking at it like they are being attacked by a hostile housing committee. And I concur with them. That's definitely what's happening. Do you have a reaction, through Mr. Chairman, to the potential, Rafi, that landlords are going to be that much more skeptical about prospective tenants, knowing that they might not be able to get rid of them at the end of the lease term if they turn out to be someone that is disrupting their entire building? And again, this doesn't have to be a really big building. This is 5 units or more, right? So my example of a 6-unit building in New Britain that I mentioned before, where someone was parking wrong and bringing roaches in the building, well, that really happened. Okay, I know the landlord. They told me about how they lost all their good tenants because they had difficulty removing a tenant under the current circumstances. Through you, Mr. Chairman.
Mr. Podolsky.
I'm not quite sure what the question there was, but I think that that with the way this bill has been drafted, the difference is not going to be significant. So if the question you're asking, do I think this is going to result for landlords of buildings with 5 or more units in making a significant, substantial difference in whether they will rent to people or not rent to people, I think the answer is it's not going to make a substantial difference. And I think that any difference at all that it makes is very much outweighed by the benefits that it gives to decent tenants who find themselves forced out for a variety of reasons. So that's the best answer I can give you to that question. We may just have to agree to disagree.
Senator Sampson.
Thank you very much, Mr. Chairman. I appreciate that answer, although it baffles me, the notion that somehow decent tenants would be forced out. Yeah, first off, I've known a lot of landlords over the years, and I got to tell you, there's conversation about discrimination, retaliation, there's all these different conversations. The only thing that I've ever heard a landlord describe to me that they expect from their contractual agreement with their tenant is that the rent is paid and they don't wreck the property. That is it. They don't care about someone's race or their gender or their relationships or any of that stuff. They just want to know that you're going to pay the rent, you're not going to wreck the place, then you are a very good tenant. The only thing that would actually change that is if there was a legitimate reason that the landlord had to reclaim their property. Otherwise, they would never want to get rid of a decent tenant, right? A decent tenant, as was described. And in those cases, like a circumstance where, they know someone that's in need and they want to provide the apartment to them, in my view, they should be allowed to. And this bill doesn't allow that to happen. It takes that right of ownership that person has under our common understanding of property rights away from them in exchange of a series of hoops that only make things more expensive. And I'm making a speech here, and I apologize. But I'll end on that note. Thank you, Mr. Chairman.
Thank you, Senator Sampson. Any other questions?